persons having anything to do before the honorable justices of the Supreme Judicial Court sitting at Portland, within and for the state of Maine, may come forth and declare it, and they shall be heard.
Good morning, everyone. Please be seated. Thank you for your patience this morning. We appreciate your patience both with the timing, we're a little bit delayed, and with the heat in the courtroom. We also appreciate the media's patience. I understand that we've had to have some organization to make sure everybody could be here and that the public can see what's occurring. So I appreciate everyone's patience in working through those matters. I want to thank Counsel. Before we begin this morning, we asked Counsel to respond to a briefing schedule which is quite unusual for attorneys, particularly in any complex matters. Counsel responded immediately. We did not get a single request to extend, and for that we are grateful, and we're very happy to see you all here this morning. I just want to remind everyone we are streaming audio live to the public. It's very important that you make sure you're clipped in and you're on as you begin to speak. And I also want to say to those that are present, we are very happy to have you all here in the courtroom. We do have some acoustical problems in this courtroom, so it's critically important that everybody be very quiet as the attorneys are arguing, and then you'll all be able to hear everything that they say. And with that, I'm going to ask each of the attorneys, just those who will be arguing, to stand, give us your name, and tell us who you are representing here this morning.
I am Cynthia Montgomery, Chief Legal Counsel for Governor LePage.
Thank you, Ms. Montgomery.
I'm Clint Boothby, and I represent Representative Timberlake, Representative Fredette, and Representative Espling.
Thank you, Mr. Boothby.
Your Honor, Tim Woodcock, representing the Maine Senate and the Maine House of Representatives.
Thank you, Mr. Woodcock. Thank you, Ms. Gardner. With that, Ms. Montgomery, you may proceed.
Thank you. May it please the court. I'm Cynthia Montgomery, Chief Legal Counsel for Governor LePage. The question before this court for an advisory opinion boils down to this. Was the governor prevented from returning the bills to the legislature within 10 days? The answer, yes, he was. We submit that there are three forms of adjournment that can prevent the return of bills. They are: 1, adjournment sine die; 2, statutory adjournment, because it is just as final as an adjournment sine die and is constitutionally and statutorily required; and 3, we believe there are times when specific facts can converge to create a situation where a non-final adjournment may prevent the return of the bills as well. In this case, the legislature let the session end by operation of law. After that, the legislature adjourned on June 30th for longer than 10 consecutive days. It dispersed. It did not create a record of its return date, and in fact, that date was ambiguous at best. Analyzing the prevention of a bill's return, the U.S. Supreme Court in the Pocket veto case said that returning a bill to its house means returning it to a body sitting in an organized capacity for the transaction of business. And the house of origin is the constitutional quorum that passed the bill in the first place. Here, our majority left the State House and did not return for 16 days. They were not sitting in an organized capacity because they had gone back to their personal lives and pursuits. Now, some have said that in that situation, the governor should just return the bills to the clerk. But the Supreme Court said a return to the clerk does not overcome the legislature's adjournment. Clerks cannot perform the duties that are constitutionally assigned to the House. Here, if all we needed was to drop off the bills with a clerk, there would be no need for a 3-day procedure, and final adjournment wouldn't prevent the return of the bills either, because the clerks are always there. The legislature is not. The Maine Constitution has this 3-day procedure to maintain the balance between the adjournment authority of the legislature and the executive authority of the veto. Here, the governor reasonably believed the 3-day procedure was triggered because the legislature had control over the 3 factors mentioned. The legislature can avoid statutory adjournment if it follows the law. The legislature can choose the length of its adjournment, and the legislature can choose the date of return. If the legislature opts, however, to adjourn for longer than the 10 days the governor has to veto bills, after statutory adjournment, and they give no date certain for return.
Ms. Montgomery,
Yes.
I'm going to apologize for leaping in. Let me first thank you for narrowing the issues, and I want to make sure we're all clear on what is not being argued here today. The governor is not asserting a pocket veto, and you have agreed, and I think everyone agrees, that intra-session activity cannot generate pocket veto possibility.
Yes.
So the governor's position is that the constitutional provision allowing him to return his vetoes to the next session, that is 3 or more days, has been invoked here.
Yes.
So let me narrow it a little bit further. In the past, this governor and other governors have, in fact, returned vetoes on facts that are similar to, but not identical to, those facts here. So I suggest to you that either the governor's argument means that his opportunity for veto at the 3-day session is non-exclusive. He could have either returned the vetoes or he could invoke the 3 days. So there would be a non-mandatory approach, which I don't think anyone argues, or that the facts in this session are so unique that, in fact, they don't follow the practice and pattern of the legislature in the past. Is it the latter point?
It is the latter, Your Honor.
So let's track through those facts. The key fact that you have relied on is the failure of the legislature to vote to extend, which it has the authority to do, while the session still existed.
We do believe that that particular fact is one of the reasons this legal conundrum has come to the position it's in. I do want to be clear, though, that at the time that the legislature let the session end by operation of law, the governor was not aware of that. And so that was not a fact that he relied on in determining that the 3-day procedure had been triggered.
So his reliance then was in the nature of the analysis that the courts who have followed to the letter the pocket veto case have relied on. That is, that the legislature was not in session, not physically present, in any of the 10-day period following the June 30th adjournment.
That is correct.
So if we accept that argument, do we not call into question those vetoes that were returned in prior years on those facts?
I don't think we do, Your Honor. It is our contention that it is really the convergence of a set of facts, a set of unique facts, that have triggered this particular procedure. Everybody understands that the default procedure is to return the bills within 10 days. But under the pocket veto case, if the legislature is not a house sitting in an organized capacity prepared to do business, the bills cannot be returned.
Well, Ms. Montgomery, that means that you are saying that vetoes need an audience, and that has been demonstrated to be untrue or inaccurate by the way that the governor has dealt with previous adjournments after the first session of the legislature. Is that really your argument, that they need to be sitting in the houses waiting for the vetoes to arrive?
It's not our argument that they need to be sitting in the houses, and that's a part of the difficulty with this case. When the legislature adjourned on the 30th without a date certain to return, that is what triggered the difficulty here. So typically, if the legislature chooses to adjourn for longer than 10 days, but gives a date certain for return, that is a different scenario than the one we faced this time.
Ms. Montgomery, it was clear that they had adjourned, no matter what you call it, that the purpose of it was to wait for the governor's actions. Even the minority leader in the House made reference to the fact that we're going to wait and act on any governor's objections on, I think the date was July 16th. So that was the purpose of the adjournment.
And the actual order of adjournment invited the governor to submit objections.
It did, but the legislature was adjourned. The legislature was adjourned and dispersed.
So
But it was not adjourned
you're relying
CADA.
on the pocket veto case. If we depart from that and look at the facts here, we clearly have staff, we have the Secretary of the Senate and the Clerk of the House actively communicating with the governor's office saying, do you have any vetoes? Just send them over, we're here 24/7. Doesn't that take us out from under the scope of the pocket veto case?
And I do recognize the difficulty there. If I could put it this way, when these facts converged, and I think it's very important that the backdrop of this particular case is that we had an extremely difficult session, to put it lightly.
So why in an extremely difficult session would the governor choose the time to do a test case? Why not return the bills and then make the argument?
As the facts unfolded in the context of this difficult session, the governor read the language of the Constitution. And the plain language of the Constitution says when the adjournment prevents the return of the bills. The governor saw this adjournment as preventing the return of the bills. He made a call.
But in the last 2 years also, let's say 2013 and 2014, the legislature also adjourned to a veto day. What is different about this year than those years? And that has happened in prior administrations too.
And what's different about this time is that in both of those examples, the adjournment was not longer than 10 days, and it was adjourned to a date certain. And that made a difference.
If the facts of the legislative history demonstrate that in one of those instances the legislature did not adjourn to a date certain, does that change the analysis?
There was one example that was raised in many of the interested parties' briefs where all three of these facts converged. The difference in that session is that there was a greater level of communication. Both of the houses had a majority of the same party as the governor, and there was more communication. When there is less friction and when things are running smoothly, people don't jump to the rule book.
But Ms. Montgomery, you cannot be making the argument that the governor was unaware that the legislature was taking a position that time was running. There were messages to the governor's office from both houses saying, we are open for business, return your vetoes if you're going to veto. So you cannot be saying that there was a miscommunication or an error. This was a decision by the governor to challenge his reading of the Constitution against other parties' reading of the Constitution.
It was a decision by the governor to follow his own reading of the Constitution. That's correct. And when he knew that the houses were dispersed, they were not present, they were not there for him to return the bills to, he didn't see returning those bills to the clerk as effectuating his constitutional
Even though he'd acted differently in the prior few years.
He had done it differently in the prior few years. The one exception was in 2012. There was extensive communication and agreement between the branches. The other three examples in his administration, the adjournments were not longer than 10 days, and they were adjourned to a date certain. There was some certainty there about when the legislature would return. And if I could add, in an adjournment sine die and also in a statutory adjournment, there's a similar level of uncertainty. We know the legislature's coming back, but we don't know when that is.
So you say the legislature was gone and things were done in the sine way as adjournment sine die. What's your contention with regard to when the bills that were either signed or vetoes were overridden on or before June 30th? When do you say those bills are effective? 90 days after June 30th or some other time?
Well, I think first of all, it depends on whether they were emergency bills, and also...
Well, okay, let's take non-emergency ones, because the emergency ones take effect when they say they do, but non-emergency bills.
Right.
Is your contention that the legislature ended, and therefore all those bills, all those laws become effective 90 days after June 30th?
I think the question to be answered first is whether those bills after June 17th, when the session arguably ended by operation of law, whether those bills actually reached the governor's desk appropriately.
Okay, so then you're even questioning the ones that are from June 17th. So, but ones that were all either signed or vetoes overridden before June 17th, is your contention they are effective 90 days after June 17th?
Yes.
So you're saying as a matter of law, the legislature adjourned on June 17th? Are you saying that?
I'm saying as a matter of law, because the legislature did not, while it was in session, extend that session and allowed it to end, yes.
Thank you, Ms. Montgomery.
Good morning. May it please the court. Mike. Thank you. I'm here today representing three named representatives, and since I initially submitted a brief, a number of other representatives have joined.
When do you contend that the laws that were all signed either before June 17th or before June 30th become effective?
We contend they become effective 90 days after June 30th.
June 30th, not June 17th.
Not June 17th.
So,
That's an arguable. We believe that's an arguable point. But things are very messy at the end of legislative session.
All was nothing unusual about.
That's correct, but it's not a game of chicken. We're trying to do the best we can for the people of the state of Maine.
So, Mr. Boothby, what is your contention, what is Mr. Fredette's contention with regard to the suggestion from the governor's office that the legislative session ended by law on June 17th?
Mr. Fredette's contention is that the action that was taken, that's a reasonable argument by the governor, but that the action that was taken by the legislature on the 18th retroactively extended the session. But it is clearly stated in the statute that the third Wednesday is the end of the session, and
Mr.
no vote was
Boothby,
taken on that day.
do we need to determine that the June 30th adjournment was in fact the sine die adjournment in order for the governor's position to be the constitutional position here?
Not necessarily, Your Honor. I know that there are certain pomp and circumstance around the sine die adjournment.
So essentially, all we need to determine is whether, as in the pocket veto case, the governor was prevented from returning the vetoes. We do not need to opine as to which of those days was in fact the final adjournment of the first regular session.
That's our position, Your Honor, and we think that because the legislature did not state in its adjournment on the 30th that it made it reasonable for the governor to interpret the Constitution to say that he had the 3-day return rule.
By saying that they were returning in order to respond to any actions by the governor, that was not clear to the governor?
Well, I can't speak for the governor. I'm speaking for some representatives here, but their position is that by not stating...
Did any of your clients indicate that the legislature was basically adjourning or recessing or whatever you want to call it to await vetoes and would act on those later?
I believe there was discussion. None of that made it into the final legislation. It's almost like a merger situation. There was all kinds of discussion about when they might return or if. We don't know. They didn't say... They didn't adjourn to a date certain. They just adjourned.
But your client indicated on the record that the adjournment was for the purpose of waiting for the governor's objections to the bills. He said that's on the legislative record, and it was in some of the briefs, correct?
That's correct. That is correct. But their expectation was, I don't know, I can't speak for their expectation, but I believe that they thought was that would make it, that some statement of when they were coming back would make it into the final enactment.
But the record says, let me quote it, beyond June 30th, which may or may not be July 16th. That's well beyond 10 days beyond June 30th. That's on the legislative record. So they knew it was going to be on 10 days, and they knew it was for the purpose of considering the vetoes.
It was their expectation that the legislature would come back at some point, but the legislature didn't make clear to the governor when it was coming back. So what?
And Ms. Montgomery has been very clear that in years when the legislature and the governor are communicating well, that process may work. So let me suggest to you that the court is only able to give an advisory opinion in this case. The parties are not before the law court here. There has not been an adjudication. Nonetheless, if the court is going to opine on the issue, it should do so in a way that in future years there's great clarity, so this confusion doesn't occur again. How does that great clarity spring from the position that you have taken?
I think that clarity comes from a statement in future adjournments when the legislature intends to return, that it state a day when it intends to return, so that there's no confusion about whether or not.
So that is the missing element here.
Yes.
Thank you, Mr. Murphy. Thank you. Mr. Woodcock.
May it please the court, Tim Woodcock for the Maine Senate and the Maine State House of Representatives. Just a preliminary comment, and I think the court is well aware of this. Although we are here in an issue that has arisen in a somewhat partisan context, these are not partisan issues that are being presented to the court. The issues that are being presented to the court here today go to the very fabric and the structure of our system of government, the separation of powers, and the principles and interests that that is intended to preserve. And lightly touching, but emphatically touching on, our separation of powers was constructed for the express purpose of preserving the liberty of the people by diffusing the concentration of sovereign power that otherwise resides with the people. And you can find that confirmed in Federalist 47, 48, and 51, and most emphatically in 51, as well as in the decisions of this law court and the U.S. Supreme Court. And it is with every case that this court considers, there are always, this will be a precedent, this will establish a roadmap for future consideration, and I know the court is well aware of that, but this being such a public proceeding, I want the public to be aware too. This is not a partisan issue. These are serious institutional separation of powers issues. The rulings of the court on this will last for the duration. First, let me address the issue of how Article 4, Part 3, Section 2 works. The plain language of that is, it's one of those constitutional provisions that shares power. There's executive power in there, there's legislative power in there. Each of these important departments has their role. The legislature is to finally pass a legislation. It goes to the governor. The governor under that provision has 10 days to return, excepting Sundays. Then he returns the bill. It is the obligation of the House and the Senate to accept the bills. That has to be physically capable of accepting the bills, and constitutional officers, including the Secretary of the Senate and the Clerk of the House, have to be empowered to do that. All those factors were met here. Where you have an adjournment order like this, and I don't believe there's been any argument that this adjournment order of June 30 was not a lawful order, that it was not a valid order under the rules of the Senate and the House. Where you have an order such as that, the governor has a very distinctive role. These bills arrive at his desk, and it is not his concern when the legislature returns. It is his concern that he discharge his constitutional obligations within that 10-day period, Sundays accepted. That's really the only standard that applies. Now, I have heard from the governor's office this morning, as the court has as well, that there is an exception to this that has a number of factors to it, none of which I might add you will find in Article 3, or Article 4, Part 3, Section 3, or Section 2. They're simply not there. But perhaps of the issues and factors that the...
Mr. Woodcock, let me press you on that.
Indeed.
We're talking about an intra-session adjournment.
Correct.
The constitutional amendments have eliminated pocket vetoes in this intra-session period, with the anticipation that the governor's veto may be presented to the next session, that is 3 days or more. In this instance, the governor says, the legislature is not in town, I will rely on that constitutional provision. If, as you say, the governor need not worry about when the legislature is or is not in town, because the legislature can always convene itself, the Constitution is very clear about that, then there would be no reason for the 3-day provision in the Constitution. There must be a purpose for that provision.
Oh, I think there is a purpose for that provision, and that provision comes into play when a first regular session of a legislature adjourns sine die and the 10 days has not run. And under those circumstances, when it reconvenes in the second regular session, then the 3-day rule applies, or if it convenes in a special session. And if I might take this opportunity, Your Honor, to address the pocket veto case. The pocket veto case was decided under Article 1, Section 7 of the United States Constitution, which, although it resembles Article 4, Part 3, Section 2 of our Constitution, is not the same in important particulars. It does not have a 3-day rule, and it does not have a same legislature rule. So what they were dealing with in the pocket veto case was not that that Congress simply left town. Congress had adjourned sine die the first session of the 65th Congress, and it was not going to start the second session of the 65th Congress until December of 1926.
So the pocket veto case is not on all fours with the facts before the court today.
Correct.
And other states have interpreted that case in a variety of different ways. Let me take you back to the 17th of June, when the legislature did not extend its term while it was in session. Did that session of the legislature end in such a way as to prevent the governor's return?
No. And first, let me trace this through the constitutional and statutory context. First, you start out with Article 4, Part 3, Section 1. And there, the Constitution tells you, both with respect to the first and second regular sessions of a legislature, when it starts. What is not in that constitutional provision is when either of those sessions ends. And I think it is reasonable to conclude that the drafters of that provision of the Constitution recognize that when it's easy to say when a legislative session starts.
But then they've expanded that by statute to in Title III, Section 2, to say when it ends.
That's exactly right.
And the statute deadline looks like it might have been missed.
But that's the interesting point, Your Honor, that I think bears emphasis here. The drafters of the Constitution could have put a constitutional deadline for each session into the Constitution, but they did not. There is no constitutional deadline on the first or second regular session.
But what they did do is make it very clear that it is the legislature that determines when it is and is not in session, not the court, not the executive branch, even though the governor can convene in extraordinary circumstances. But if the legislature has enacted a bill that says, after this date, we are not in session, unless there has been an extension, should we not recognize that as meaningful?
Well, of course you would recognize it as meaningful, but you also have to look at what is not there. In the first place, it is a statute, and it is a statute because the Constitution wants it to be a statute, directs it to be a statute. Now, the legislature, in obedience to the constitutional directive, did in fact enact such a statute. But what is not in the statute?
Are you calling that statute advisory as to the legislature?
Let me put it this way.
Is that what it is?
Let me finish this thought.
Isn't it
and then
there
I'll address
because
your
they
point.
wanted the legislature to have the opportunity to pick its own end date, and it did by law? It could change the law, I suppose, if it wants to change the end date, but it did not.
Well, let me back up on this, and I will address both points if I may. First, take a look at Title III, Section 2, and look at what is not there. What is not there is nothing in that statute that says if the legislature meets the third Wednesday of June and does not on that day extend the session comes to a close. With that, now, one would have to assume that the legislature, when they passed that law, could have put that kind of a limitation in, and they did not. And this is the very same provision, I might add, that authorized the legislature to add 5 legislative days and another 5 legislative days, and then one more for a veto day. The legislature could have put into that statute, if it wished, a limitation that said if the legislature does not exercise this power by the third weekend or the third Wednesday in June, it loses the power.
But didn't it say that in the event of an emergency, it could vote to extend? But doesn't that mean that they have to be in session to be able to vote to extend? And weren't they out of session on the 18th?
They were not out of session because nothing in that legislation, that particular statute, prevented them from coming in and saying, we wish to take advantage of the 5 legislative day extension. And I might add in that particular, I think here we are dealing with, because the earlier legislature that passed that particular statute did not limit the legislature generally in that way, and I suspect they did that deliberately. What they were, where we are right now with the exercise of the power on June 18 is Article 4, Part 3, Section 4, which is the constitutional authority of the legislature to make its own rules. And keeping in mind in that particular, this was not a provision that was put in front of the legislature by sleight of hand. Anybody who has read the legislative record on June 18 knows very well that the question of whether the legislature could do this was squarely teed up for legislators to consider and was even discussed. And at that point, within the context, again, of Article 4, Part 3, Section 4, I would say any legislator, any representative, any senator could have stood up and raised a point of order and said, we are beyond the statutory deadline, we can't do this. And that then would have become an issue that would have been ruled on by the chair. That would have been the appropriate context within which to work on it. And
so let me make sure I understand your point. The legislative history on that particular piece of legislation is very slim and appears to relate primarily to the ability of the exchequer to pay legislators for those additional sessions. There's a great deal of concern about assuring payment. There's nothing in the legislative history or the language of the statute itself, and I assume this is your position, that indicates that that extension authority is intended to address the actual authority of the legislature to work. It's intended to address what is essentially the logistics of payment to the legislators.
Well, it would be, let's say, consistent with human nature that would have been the focus. But I would say that what we would be looking for in the statute, the bare wording of the statute, is some limitation on the legislature to do this. Now, in that particular, if we assume...
Is your contention recognizing Article 3 of the Constitution that we really shouldn't even get into that because that's a matter exclusively within the province of the legislature to decide when and how they extend their sessions, or if they do?
I think that is exclusively within the province of the legislature, and therefore... And that is consistent, by the way, Your Honor, with the care that was taken to insulate the legislature from historic encroachments on legislative prerogatives that came from our experience with the British and that were repeated. That these were the lessons of the English Civil War, which we learned so well and applied in the structure of our own government.
Mr. Woodcock, both you and the Chief alluded to the fact that our answer to the question should provide clarity, a plan for the future. Isn't the cleanest, clearest, simplest approach to this for the court to gravitate to sort of a strict interpretation of the pocket veto case and simply say, if the legislature's out of town, if they're not doing business, that prevents the return. If they're in town, they're doing business, you can return it. That provides absolute clear guidance.
And a great deal of burden as well, I think, Your Honor. And that raises the question, I would say, let's assume for a moment that the legislature has to be in session. And I would say, submit to the court that Wright versus the United States, which followed on the pocket veto case, essentially said the opposite, or at least said they don't have to be right there as long as they're constitutional officers or they are prepared to take the bills and make the proper journal entries. But think about this particular situation. You get to June 30, the legislature has nothing left to do. There's no reason for them to be in town watching the clock. They can leave. What purpose would possibly be served by them sitting around the legislature waiting to hear from the governor? And I might add, I do think it is...
Well, let me stop you there, Mr. Woodcock. This whole provision of the Constitution is to assure that the legislature can do its job and that the governor, in fact, can be heard in veto. So there is a serious reason for the legislature to be present when the governor returns the veto.
But there's nothing more the legislature can do. The legislature has finally passed the legislation. It may well be that in the interim discussions occur that may obviate the need for a veto or may lead to some legislation in a subsequent session. There's nothing more for the legislature to do. It cannot recall the bills that it has sent to the governor. The governor's duties are clearly spelled out in Section 2. He has 10 days, Sundays accepted, to return his objections.
Under Article 4, Part 3, Section 12, there's a provision that the House, and this is the Constitution, the Senate and the House have to agree if they're going to adjourn day to day for more than 2 days. Would it be the position that if they, in fact, leave town for an adjournment that was voted by Article 4 Part 3, Section 12, that the governor can't return vetoes within those days, even though the Constitution says day to day?
That's temporary adjournment. As part of the original 1820 Constitution, that's a temporary adjournment. The clock would still tick. So under those circumstances, unless they have adjourned...
Even though they're out of town, the vetoes can be returned during those days contemplated in in Section 12, let's call it.
Well, yes, that's true. And one of the things I think has been highlighted by the exchange of briefs in this matter is that the Clerk of the House and the Secretary of the Senate were fully prepared to receive the return bills and to fulfill their constitutional duties to enter them on the journals and make them available for the legislature to consider. And I might add, and the court has already asked this in its questions, but it is crystal clear that this order of June 30 was deliberately structured for the purpose of allowing the governor to return the vetoes. I mean, it's clear as crystal. There can be no doubt about it. And I just want to make this point, if I may, before I depart here. It cannot be that the rule that applies, that differentiates this from other sessions, is that there was contentiousness. Tension is built into the separation of powers. It's a shared power. And there's going to be tensions, and they're likely to be heightened in nonpartisan or partisan situations. That can't be the constitutional rule.
Thank you, Mr. Woodcock. Ms. Gardner. Ms. Gardner, now that you are mic'd, thank you for your patience with our system. Let me ask you this. The position that the governor has taken in this case is both reflected and approved in the analysis of several states' highest courts. So if you look at what Connecticut, New Jersey, Delaware have done following the pocket veto, the requirement that the legislature be present at the point that the vetoes must be returned within that 10-day period has been adopted by those courts. Given that the chief executive has urged this adoption, why shouldn't we go with the courts from Connecticut, Delaware, et cetera?
Well, first of all, Your Honor, that is clearly the minority of jurisdictions. The very vast majority of jurisdictions has held that a temporary adjournment during a regular session does not prevent return of vetoes. And I think it's really important to note, I don't think others have pointed out yet, in the pocket veto case, Congress had adjourned sine die its first session. This legislature had not adjourned sine die this legislative session. This legislature, between June 30 and July 16, was empowered to conduct business. All it required was a beckoning signal from the Senate President and the Speaker of the House to say July 16 is the day. And I think it's very important to point out, as you know, the legislature has plenary authority, only limited by express provisions of the Constitution. And the governor has the choice to do a line item veto or a general veto within his 10 days. The legislature may not know which day it wants to come back into session. So to try to suggest that the legislature has to specify in its motion for a temporary adjournment a specific day to return is limiting the legislature's power in a way the Constitution simply does not authorize. So this is clearly...
But there is some fairly broad language in the pocket veto case regarding the actual presence of Congress for a response to a presidential veto.
There is, Your Honor, and the Wright
Was that
versus
dicta?
U.S. case, the Wright versus U.S. case clearly retrenches from that position and says there is no reason during a regular session, which is a factual distinguishing fact between pocket veto and Wright and between pocket veto and this situation, that there's no reason for the body, the House or the Senate, to be within the walls of its chamber when the governor returns the veto. Return of a veto message is delivery. It is not an opportunity to speak to the legislature. It is not an opportunity to lobby or to negotiate.
Would the facts be different if Maine were a state in which historically, through practice, the veto is actually returned to the sitting body. There are states in which the paper vetoes with the governor's statements are taken with some pomp and circumstance through the halls to an active Senate or House, with the pounding on the door and the delivery to the actual members of the Senate or the House. Would it be different if Maine had that tradition?
Not if the tradition might be somewhat informative, but you couldn't read a constitutional limitation on legislature's power by virtue of that practice.
In the pocket veto case, or perhaps in Connecticut or somewhere else, if you research those laws, is there any constitutional provision similar to Article 4, Part 3, Section 12, that contemplates day-to-day adjournment with agreement of both houses, and says that if the adjournment is more than 2 days, they have to agree, but doesn't put a cap on how long that adjournment might be? There was nothing like that in the federal Constitution that would affect the pocket veto case, and that clearly was is a day-to-day adjournment under our Section 12 that makes the legislature available to receive things.
Yeah, I haven't done a comparison with other states on that specific provision, Your Honor, but again, this is clearly...
But that was the provision under which the legislature adjourned on June 30th and June 18th, isn't it?
They adjourned on the call until the call of the Speaker and the Senate President, and as Mr. Woodcock pointed out, with express reference to when there is a need to conduct business or to consider possible objections of the governor. That is why they adjourned temporarily for more than 10 days. That is why in the last...
Ms. Gardner, it would be a lot clearer if the Constitution said an adjournment, instead of talking about that prevents the return of papers, just said an adjournment that ends the session. Wouldn't that be the clearest way of solving this uncertainty?
I think that is the clear meaning of the Constitution, Your Honor, even though those words are not used. And I would say to the justices, there are important separation of powers principles.
The words adjourn, sine die are used in Section 20 of Part 4, Section 3.
That is true. That was a later provision, but I don't rule here to protect separation of powers and a bright line. And the bright line is the only form of adjournment that prevents the return of vetoes is an adjournment sine die, and it is the legislature's prerogative to determine when that occurs, and they have a long historical practice of formality in declaring that, and that is the bright line that the justices should articulate to guide the governor.
Thank you, Ms. Gardner.
Thank you very much.
Ms. Montgomery, to save time as you are retrieving the mic, let me indicate I
believe that the right case did clarify in that it relied on the other constitutional provision that said a short adjournment, not a lengthy one and not one with an indefinite date of return, that a short adjournment in the session doesn't prevent the executive from returning the bills. That's not what we have here.
So for clarity, as the court gives advice, it's your position that unless the legislature announces its date of return, it has, at the end of the session, adjourned sufficiently to prevent the return of vetoes.
It's our position that if all three facts come together. So, statutory adjournment occurs first. If the legislature extends that statutory adjournment, there are only 11 legislative days left. And so it is during that 11 legislative days that we are concerned about the tip in the balance of power. So yes, that has to happen. The adjournment longer than 10 days, and finally, no date certain for return. Having said all that, we're not suggesting that that is the only circumstance under which the bills might be prevented from being returned, but those circumstances certainly should raise a flag about the risk to an imbalance of power.
But are you saying the adjournment was on June 17th? Or are you saying it was an adjournment on the 30th because they didn't give a specific date? Which one?
Well, I think that's a difficult question to answer, Your Honor. On June 17th, it is our position that the session actually did end by operation of law.
So you make an alternative argument?
I'm sorry?
Are you making an alternative argument that it ended on the 17th, but if it didn't, it ended on the 30th?
Yes.
Thank you, Ms. Montgomery.
Thank you.
We very much appreciate the briefing and the argument of counsel here today.
All persons having anything further to do before the honorable justices of the Supreme Judicial Judicial Court may hence depart and give their attendance here at the call of the Chief Justice as this court now stands adjourned. God save the state of Maine and this honorable court.
Here, but